It's not moving. We got 35 people in here. We'll give it a few minutes for people to get in here before we get started. Can you hear me, bro?
Yep.
All right. I got some yeses in the chat that they're hearing me. All right, we got 115 of you guys in here, and I think we can go ahead and get started. So today's topic was First Amendment training that's put together by the New York State Conference of Mayors. And before we get into that, I brought up the website here on the screen here so we can get an idea of what they're about. And if we look here at their mission statement, it's pretty much association. I don't think that it's a government-run association, but it has some standing with the public or the government because all the mayors are part of this association, and it's pretty much looks like a way for all the governments to get together and communicate about different policies and that. And there's a lot of different stuff on here. You guys can check out the site when you're later. Go ahead get into the leadership so we can go ahead and oust all the mayors that are involved in this today. Um, these are all the executive committee presidents. You can see where these mayors are from. This is the mayor of Hamilton, New York, the mayor of Olean, New York. We got the mayor of Min, Iowa. I might have mispronounced that wrong. Albany. But you can see where all the mayors are. We can see Eric Adams in here, so we know the shit's dirty, of course, under federal investigation. Brockport, I had my run-ins with her. She tried to remove me from the building using the police. It didn't work out in that audit. See, we got all the mayors of Hornell. These are all the mayors that are part of this association. So when we go through this, you can realize who all the mayors are about this. And then we have the staff. And the staff here is also, part of this. And the person who's putting this on is this guy right here. This is Wade Baltimore. We have his contact information for anything you guys feel that he's teaching our government how to divert around the First Amendment rights. And you'll see throughout his presentation how he stands. He knows it's wrong. He knows that they shouldn't be doing it, but he's still telling them how he thinks they can do it as a council. And it's actually quite disgusting. So we'll go ahead and get into that. Let me just go ahead and put this up here. So this is Wade here. This is how you can contact Wade if you feel the need to redress your grievances to a man telling the government and teaching the government how to circumvent our constitutional rights. So you guys, before you go making any decisions, let's go ahead and get into the video here so that we can start listening here. Just bring up the video. All right, so when I start playing this, guys, you guys let me know if you all can hear it in the chat because sometimes audio sharing isn't good. So you guys let me know in the chat if you can hear it. Rogue, you let me know if you can hear it as well. So let's go ahead and get into this movie. It looks like Rogue just dropped out on us. He'll probably be right back. Maybe having internet issues, but you guys in the chat, let me know if you guys can hear this. Oops.
A copy of this PowerPoint presentation in the chat box. You can download it from there. I've uploaded it there. It's the slide deck handout. Good morning. My name is Wade Beltramo. I'm General Counsel here at the New York State Conference.
Are you guys all hearing the video? Throw one in the chat if you can hear it. We'll give it 1 second here to see if Rogue is going to join us back here. He's not in the basement yet. He might be having some internet issues where he's at. We'll give it a second, then we'll go ahead and get into this. And then at different points, we'll pause it and we'll bring up some different stuff. We'll talk about, like how this guy, he knows it's wrong, but he's going to circumvent it anyways. It's kind of crazy. Let's see if I can maybe give Rogue a call and find out what's we got going down.
Yeah, I saw I got kicked, dude. I'm having some issues on my computer.
Do you have internet issues?
Yeah, it might be the internet, might be my computer. If it keeps up, I'll just hop on a different account on my phone. So if someone else comes up, it's going to be me because I'm the only one with the link.
All right.
All right.
All
So
right.
let me try this on my computer. If not, I'll hop back on my phone.
All right.
All right, later.
Rogue's having a little technical issues, guys. We're going to wait for him for a few seconds here, then we'll get started on this video. The video itself, as you can see, it's about an hour and 25 minutes long. We assume this is probably going to go from about 8 to 10 because we're going to pause and talk about some different stuff. And seeing as we're already in here 6 minutes and we haven't really started, let's see, we got Rogue up in the basement. Let's see, we add him to the stage. We there, Rogue?
Yeah, I'm here. Yeah.
All right, we're going to go ahead and we're going to go ahead and rip this video and get it started. If you want to stop the video for any point, or I want to stop the video, I'll just stop it. Otherwise, you speak up, or shoot us a raised hand or something. We'll stop it if you want to address anything, because there's a lot of shit he's going to say in here that is falsehoods and kind of nuts that he knows it's wrong, but he's still advocating for these cities and towns in New York here. The other thing I want to bring up is a lot of this is going to be New York law, but even he's going to bridge to like other state Supreme Court's rulings on stuff to try to use it. So understand that a lot of the terms he's going to use here and say are about New York state law as well. So here, let's get into it.
Conference of Mayors. I want to welcome everybody who's joining us this morning for this webinar on First Amendment audits and how to kind of handle and respond to those. This has been an issue that's been going on for a while now. This is not the first presentation I've done on this. I did my first webinar over a year ago. I just did a training at our fall training school last week on this topic as well. So we know this is becoming more and more of a hot topic. And in just the last several weeks, a lot of municipalities in Western New York, down in the Hudson Valley, down on Long Island, have had experiences with these First Amendment auditors. So I'm going to cover this today, hopefully in a methodical manner. I like to think that it's methodical to give you an understanding of how to approach this. I don't have a sample policy, and we'll talk about that a little bit more, because it's really, there's no one-size-fits-all approach to this. There's a lot of flexibility on what municipalities can do in dealing with these, and that's really a decision that has to be made by the local officials. Like, how do they want to proceed with respect to these First Amendment audits? So the first thing I note, and I do quite a bit of training on First Amendment issues for our members, because what local government officials do frequently touches upon protected First Amendment activity. But the First Amendment is a minefield. It is a difficult issue for even seasoned, experienced attorneys to deal with in many instances, and let alone a lay.
When he says it's difficult to deal with, what he's saying is it's difficult to get around it in for the government's favor is what he's really saying here.
Lay local official who doesn't really have any training or experience in dealing with the First Amendment. So I want to recognize this. The First Amendment is not an easy thing for government officials, state, federal, or local level to deal with. So that's where we're at when we're dealing with these First Amendment audits. The first thing I know, and this happens all the time when I get a call from a mayor, a trustee, a council member, a clerk, a treasurer, regarding the First Amendment issue, is consult with your own attorney. Because of the complexity of these issues, you really do need to be engaging with your attorney. By all means, members of the Conference of Mayors can come to me. You can call our offices. Most likely you're going to be getting me. You might also get my colleague, Rebecca Bracito, who's behind the scenes today, this morning on this webinar. If you have any questions, put them into the Q&A dialogue box. I will try to get to them. Rebecca also will be answering those as we go along, to the extent that they're more appropriate for her to respond to as opposed to me during the presentation. But consult with your own attorney. If you're drafting a regulation, if you're putting in place a a rule, if you're enforcing something that touches upon the First Amendment, whether it be a First Amendment audit, whether it be the regulation of signs, whether it be protests that you're having in your community, government speech, which is another hot topic because of a recent Supreme Court decision. Consult with your attorney. The second thing I'll say is anytime you do a regulation, and this isn't only with respect to First Amendment activities, but any type of regulation is
Dan, hang
really
on for a second.
achieve. And
I just want to put it out there. He keeps talking about, take this up with your local attorney. But 9 times out of 10, your local attorney is trained in municipal law and not civil rights, or you know what I mean? So that's why a lot of these cities are passing these policies, because they don't understand, right? Even their lawyers don't understand sometimes. So it's more nuanced than this guy's even making it out to be. But so, yeah, that's all I just wanted to say, was that, these guys consulting with their attorneys not always going to get them the effect that they want,
And to point out that the only reason he's saying consult your attorney would be, he knows it's wrong. He knows it's almost impossible to get away with in the long run, to make, First Amendment auditing illegal, or, filming where the general public is allowed to go. He knows it's going to be a minefield. That's why he's even bringing that up in the first place.
are there potentially other non-regulatory steps that you can take to achieve those results? And an example I give of this is, dealing with door-to-door solicitors. That's another protected First Amendment activity that's really problematic. It's difficult to craft a local regulation that is constitutional on its face. It's difficult to enforce such regulations. I wrote an article several years ago for NICOM's magazine, where the gist is, should you regulate or should you educate? Should you educate your public about certain issues, or educate your staff as well? And we'll talk about that today. So that's just something to think about. Is your regulation, is it really necessary? Are there other steps, other things that you can do to address your concerns? Because I think there frequently are, that are going to be just as effective, if not more so, than adopting a regulation, and easier to implement, much easier to implement. If you are going to go down the route of regulating First Amendment activity, keep it simple. Keep it simple. I can't stress this enough. The more complicated your regulation is, the more likely it is to be unconstitutional. And we've seen this time and again. The Reed case, the Reed sign case versus the town of Gilbert, which is from 2015. It was an extremely complicated local regulation that ran afoul of constitutional protections. It put signs into 23 different categories, and that should have been a red flag for the local officials. It should have been a red flag for the attorneys who were advising them that this was gonna be a problem, right? And so keep it simple. And I'll talk about that today too. Hopefully the advice I've been giving is relatively straightforward. I can recite it, and so should everybody else be able to recite my advice. Adopt a policy, post signage, train your staff. 3 steps. That's it. When I say that's it, there are obviously some nuances to that, and I'll go over that. And then finally, again, consult with your attorney. Consult with your attorney, not only about the crafting of a regulation, but also its implementation. How is it enforced? Discuss this with your attorney. So with that said, let's dive into it. I mean, we're dealing here with First Amendment issues. It's always important for everybody to understand and kind of refer to the First Amendment every once in a while. Important to recognize the First Amendment actually has like 4 different types of protections that are in it. The Establishment of Religion Clause, which is its own area of law and can be challenging.
Hold on, Dan.
The protections against.
He's gonna try to bunch speech and press together.
Right. He said there's 4 protections, and trying to bunch speech and press together. That's
I think that's what he's gonna do. If you want to hear him out for a second before we.
Yeah.
But hold on, let's hear 'em.
It's prohibiting free exercise of speech or abridging the freedom of speech or the press, the right for the public.
So he's going to go ahead and bridge the press and the speech together, which are two separate, rights. I mean, like, your free speech to yell and say whatever you want is totally different than silently collecting film. I mean, that's even been ruled on in the courts.
Right, and that or there, a lot of these guys that read these laws always seem to forget what or means, right? Because they do it in poster 7, right? They're always talking about, well, there's no public meeting in the lobby. And I'm like, no shit, idiot, because the public meetings are in the auditoriums and it's after the word or, right? It's not lobbies and auditoriums, it's lobbies or auditoriums. So it's either or. And the same way here with the abridging the freedom of speech, comma, or of the press. Either or. They're not together. It's one or the other. Or learn it, love it, live
I mean, if you count out all them after the words or, you're counting out 5 there anyway. So, but yeah, the government loves to, because where they get this doctrine of, all these doctrines of limited public forums. This limits speech. It limits your speech. It limits your ability to go into town hall with a big old sign, F the mayor, out loud and disrupt the business. But that's totally different than silently stand there filming. These are two different rights. And the government loves to screw them and put them together.
To peaceably assemble, right? So protests and the like. And then also finally the last category, the right of individuals to petition the government for redress of grievances. We're really focused here today on free speech, and I'll get into that a little bit more in a second. But what I do want to cover is kind of some general principles impacting local government regulations when it comes to First Amendment activity. I think it's important for everybody to understand these general principles. And the first one is that as a general rule, when local governments act, when public agencies act, and for specifically enacting a local law, so long as you follow the proper procedure, and with respect to New York cities and villages, the procedure for enacting local laws is predominantly located in Section 20 of the New York State Municipal Home Rule Law. So long as you follow that procedure, you provide notice, the proposed local law is aged, you have a public hearing that allows public to comment on it, it's filed with the Secretary of State's office. As long as you do those steps, the starting point for any legal challenge to a local law is that the courts are going to presume that it's constitutional. They're going to give local government officials the benefit of the doubt, right, with respect to...
Do you see what he says there? And he knows it. He knows the government is going to favor the government, and he's literally telling these mayors to take advantage of it. This Wade is a slime ball, guys.
Right. Hold on. I got to say something there, because not only does this apply with the local law being passed, but this applies to every government agency agent, right? This is why I tell people you got to get your evidence, right? Because just going into court, you're already behind the 8 ball, because the judge already presumes that the government, who is charging you, by the way, is acting in moral and upstanding and righteousness, and you're a scumbag, pretty much, is how the court looks at you from day one. And it doesn't matter if you're a doctor or a lawyer, or if you're P. Diddy, or however much money you got, or it doesn't matter about any of that. This is the way the court works, right? It presumes that the government is the choir boy, and you know what I mean? And you're the devil. So
and that all that he just mentioned, all that happens before the mayor and the judge and the all the cops are all golfing together, guys. So just remember, collecting that evidence, always record your government. And if they weren't worried about you recording them to catch them doing stupid shit or saying stupid shit, and And if they thought that you recording that was a problem, we wouldn't be here right now with their little spiel about how you got to stop the First Amendment from, so they can be crooks, right? Well, where's the transparency in government? We're going to stop the camera in the publicly areas. We're not even trying to get in the restricted areas, for God's sakes,
And also, hold on, this is a very important point too. This is why it's so important for everybody to keep their government officials accountable, because what he's basically saying here is that the legislature can pass any kind of law they want, and until it's challenged, it's presumed constitutional. And he's absolutely 100% right, which is how we know that people in Chicago couldn't own guns for 30 years, right? Because no one challenged it. So, or if they did challenge it, they lost. It was a court that didn't decide in their favor at the time or whatever, and they didn't get it up to SCOTUS, or didn't have the money or what have you not. But this is part of the issue, right? Because if there's a law passed, it's unconstitutional, you try to fight it. Maybe the first court doesn't go in your favor. Maybe you take it to the Court of Appeals. Maybe they don't go in your favor. Maybe you got to take it to the Supreme Court now for a local law, right, that restricts your rights. You're out. If you're not doing it yourself, you're out. What, 250 to $750,000 taking that municipal law that they passed. So this is very important when it comes to what your local government's doing, because they can pass literally anything they want, like literally, and it's constitutional until it's challenged. And we've seen some
that's it.
stupid laws.
That's exactly what happened here in New York with the gun laws. They had, all these gun laws that they passed, and then the Supreme Court literally knocked down the gun laws on the pistol permits in New York. And then a week later, they just wrote the same law, just a little different language, and now it's once again constitutional illegal until somebody takes, $250,000, takes it to the Supreme Court to get rid of it again. And that's what they do. So just remember, you always want to record your government because they are liars.
To your local regulations. And this is on the one hand, really for a practical matter, right? They don't want to create a too stringent of a standard that would basically inundate the courts with challenges to local regulations. Okay, so that's where we start. We start with a presumption of constitutionality for any local law, any regulation that's adopted by a municipality. However, as soon as someone asserts that the regulation impermissibly impedes upon a constitutionally protected right, and in this context of today's webinar, the First Amendment, the courts are going to sit up, they're going to take notice, and they're going to say, hey, wait a second, this individual has made a prima facie assertion that the local law unconstitutionally infringes upon their constitutionally protected rights. And as soon as that happens, the courts are going to look up and they're going to put the onus or burden back on the municipality to justify their local law. And so when that happens, local officials need to be prepared to defend their local law a little bit more stringently than they otherwise would have to defend a local regulation, right? Say, for example, a local zoning regulation or a local business regulation that doesn't impact First Amendment activity. So what are some of the things that local officials and attorneys should be aware of? First of all, when you adopt a local law regulation that touches upon First Amendment activity, it shouldn't be overly broad. It needs to be focused on addressing the concerns that you're seeking to address, but not more than that. And this goes to, and you'll see it in the later on, I'll use the term narrowly tailored. If a local law infringes upon First Amendment activity or regulates First Amendment activity and it's overly broad, courts are generally going to frown upon that. And so that's a concern. Also, your regulation shouldn't be under-inclusive, right? So if you're seeking to address a certain concern and you put in place a regulation that impacts speech, it should really be focused on all of that speech. If you're infringing upon or restricting certain speech, but not other speech, the courts are going to look at that and they're going to say, hey, this is under-inclusive. Why are you doing this? You're actually giving preferential treatment
One thing I want y'all to notice about Wade is how he knows what governments can and can't do, but he's like, "What if you're gonna do it? Just be ready, prepared." There's no point is this guy adding any counsel to these mayors to be like, "Listen, you guys swore an oath. Be careful what you're doing." It's like, if you're gonna do it, just be prepared to fight it. This guy's a real slime ball of counsel.
To the speech that is not regulated by your local regulation. And that's problematic, right? So we have, it can't be overly broad and it can't be under inclusive. It really is kind of a Goldilocks principle that local regulations that impact First Amendment activities need to be just right, okay? Another issue that is extremely problematic for local officials, and that is when they give discretionary enforcement authority to a local official. Discretion is a red flag when it comes to protected First Amendment activity. Regulations that allow or provide for discretionary enforcement are frequently going to be struck down because that creates what the courts have kind of interpreted, and rightly so, as a chilling effect. If I'm an individual and I don't know how local code enforcement or police or local officials are going to interpret or enforce a regulation, it might cause me to kind of not invoke or express my or exercise my First Amendment protected rights. And so that's definitely going to be a problem too. And the way you would address this is making sure that it's very clear what your enforcement officials can and cannot do. I'll talk about this a little bit later when we get into the specifics of the regulations or regulating First Amendment audits. And then finally, any regulation that is not clear, this goes hand in glove with that discretionary aspect that I talk about there. Any regulation that lacks clear guidelines, that's going to be problematic as well. It leaves individuals in the position of having to guess, of having to be afraid that their actions, their speech is going to subject them to an enforcement activity. And that chilling effect is frowned upon by the courts, right? So what can you do generally as local government officials with respect to regulating protected First Amendment activity? And the first thing is that all of your regulations should be content neutral. That's your starting point. If your regulations touch upon the content of action or speech or activity, that's going to be a red flag. That's going to be very difficult for the municipality to justify and withstand a legal challenge, right? However, if your regulation is content neutral, at most courts are going to apply only an intermediate level of scrutiny of that regulation. And what is that standard? As a general rule, in the simplified terms, the intermediate level of scrutiny by courts
I seen you come unmuted. I knew you had something to say about that.
Yeah, and I'm gonna go away from StreamYard here for a second just to look at my thing, so I'll just read it to you guys. But this is something I was just looking up recently. This is the City of Ladue versus Giglio, I guess. It's a SCOTUS case, 512 U.S. 43 from 1994. And it says here that although prohibitions foreclosing entire media may be completely free of content or viewpoint discrimination, the danger they pose to the freedom of speech is readily apparent. By eliminating a common means of speaking, such measures can suppress too much speech. So, because again, this is all the stuff that he's talking about is stuff that me and a few others are fighting in court with civil lawsuits at the federal level, right? We're hearing all these arguments. We're hearing the public forum doctrine. We're hearing, these regulations can be, yada, yada, yada. So, I mean, we really got to dig and flesh out this stuff because, you need to lead people, it seems like, almost along a path for them to understand. And even then, sometimes they don't understand. What seems crystal clear to one person is totally foreign, maybe to another person, depending on what they believe and what life's taught them. They might have different experiences and different beliefs, so they'll look at something totally different, which is why two people can witness the same event and have two different outcomes of the event. So that's always important to note. But yeah, I mean, for those of us like me and Dan and a lot of the folks in the chat that are really interested in fleshing this stuff out, because there is a difference, right? Like when Dan's talking about they're trying to restrict our speech, what these guys are trying to commingle speech and press together. That's what they're trying to do. They're trying to restrict it because the press has always been about the right to watch government, right? Now, a lot of people will tell you that they think that the free press means that we can publish whatever we want without government interference. And that's also part of the right to free press. But the constitutional importance of the free press, like the essence, right? The lifeblood of the free press is watching the government, right? That's why they called it the fourth estate, right? Because there's three branches of government, and then there's the fourth estate. And the fourth estate is the watchdog. It watches the three branches, right? Look all this stuff up. Research, Google the fourth estate, right? That it's specifically called the fourth estate. And there's a reason for it. And if you go back and you read what the founders wrote and you read all the legal scholars, Justice Thomas Cooley and his general principles of constitutional law said exactly the same thing. The right to free press is the right to watch over every single official and bring their actions to the public so we can make wise decisions about who's running our lives, because these people are running our lives. Whether you want to say, oh, I'm a free man or not, these people are running your freaking life. Right? They're telling you how much taxes you got to pay, right? They're putting the regulations that make the bread go up 50 cents. They're putting the regulations on the gas that makes it go up 50 cents. These people are running your lives. And when you look at our videos, you notice these are the same chuckle fucks that you knew in high school, right? They ain't gotten no smarter. They're the same chuckle fucks, and they're running our lives, right? They're idiots. None of these guys are Mensa members. None of these guys are Stephen Hawking, level people. These are the same chuckle fucks that you went to school with, that you were like, damn, that dude's a chuckle fuck. I guarantee you, if you look back at all those kids you thought were chuckle fucks in high school, 3/4 of them are in government. I guarantee it. I guarantee it, bro. All right, Dan, let me stop interrupting, brother.
All right, let's go ahead and play that on.
Require that the government demonstrate a significant government interest, and that's more than the presumption of constitutionality, right? Normally, courts are not going to get into what your interest is in regulating activity, right? They don't like to go there. But when you touch upon First Amendment activity, they're going to want to say, hey, what's your interest in regulating this expressive activity, this speech? So that's the first thing. You're going to have to demonstrate that there's a significant government interest. The second thing is that your regulation is going to have to be narrowly tailored. And this goes back to the overly broad, under-inclusive principles, right? It needs to be just right to achieve your government interests, okay? And then finally, there need to be ample alternative channels for the individuals to engage in their expressive content. So, significant government interest, narrowly tailored, ample alternative channels. Also, when we talk about what is, narrowly tailored, and many people have heard this time and again, the standard of being able to adopt content neutral regulations that apply reasonable time, place, and manner restrictions. That's what we're looking at. That's your bread and butter. That's what you can do as a local government. Impose content neutral regulations that are reasonable as far as time, place, and manner. So I'm not going to dive into that in depth this morning because I really do want to focus on the specifics of the First Amendment audits, but that gives you kind of an overview of what you can do generally when adopting regulations that impact or touch upon First Amendment activity. The red flag here, content-based regulations. If you have a content-based regulation, the courts will apply strict scrutiny, the strict scrutiny standard, and that's really, they require you to articulate and demonstrate a compelling government interest as opposed to a significant government interest. And very rarely is a local government regulation going to withstand the strict scrutiny analysis, right? So if you're an attorney and your client comes to you and they have a content-based regulation, as a general rule, you're going to say, like, let's not waste our time. We gotta admit, hey, we screwed up. This shouldn't be on the books. We're gonna recraft that. So I just put that there. If you go down this route, you're begging to get sued and to lose that lawsuit as a general rule. So I say this time and again, consult your attorney if you're enacting a local regulation that impacts First Amendment activity. Let's dive in specifically now to First Amendment audits. The first thing I'll say is this is a made-up activity. You'll notice that there's nothing in the language of the First Amendment that says, oh, the right of individuals to conduct First Amendment audits shall not be abridged, right, by government.
That is incorrect. The Constitution clearly says the prohibited of the free press, and the First Amendment auditor is a member of the free press. So this guy is wrong. It does say that in the Constitution. The Constitution is a living document, of course.
Official. And the court doctrine, there's never been a court that has come out and said, oh yes, these First Amendment audits are protected First Amendment activity.
Once again, that is also incorrect, because when I was on federal probation for the J6, the probation or judge who originally sentenced me to 45 days in prison and 2 years of probation, which as of tomorrow I only have 1 week left of. But when I got out of prison, the judge enacted a part of my condition is I can't step foot on police department property. Well, in another week I can, but so when I got out of probation, they took me before the federal judge and tried to make it illegal, or try to make it a probation violation of me to go into a public building and film a First Amendment audit. And the judge of the judge, I think my mic just went out. Can you guys see? All right. So the judge of the Western District went ahead and said that if they limited me from doing a First Amendment audit, that would be a violation of the First Amendment, my First Amendment rights. So there is a court ruling on it, and here in New York, a federal court ruling.
Having noted that, right, I can't stress this enough. Recording is protected First Amendment activity. And I should step back. I think everybody knows what we're talking about when I mention First Amendment activity. But generally, we're talking about individuals, First Amendment audits. We're talking about individuals coming into a city hall, coming into city offices, village offices, town offices, local government offices, and recording. They're recording at the clerk's office. They're recording in the water and sewer office. They're just walking around recording officials. They may also constitute First Amendment audits. They may walk around the exterior of a facility, the county jail, the city hall, village hall, DPW garage, whatever it is. But most of the ones that have gotten a lot of attention are individuals actually coming into public offices and recording local officials. They also do some other things like submit FOIL requests and ask for officials' names. I'm going to talk about that at the end, but that's really what we're talking about, this aspect of recording. And I will tell you, 20 years ago, there wasn't a lot of case law on this, right? There was a little bit about recording, but really the proliferation of mobile phones, has expanded this significantly. And I will note that most of the jurisprudence with respect to recording, and that as a First Amendment activity, involved individuals recording police officers making arrests or having interactions with the public out on public streets, on sidewalks, in parks, not within city or village hall. Most of this jurisprudence, and there is a ton of jurisprudence on this, there are a ton of court cases where the courts have said, hey, recording is protected First Amendment activity. In fact, every circuit court has ruled on this issue, and it has come down on the side that says, yes, the public recording, public officials conducting their business, their work, their activity is protected First Amendment activity. And the rationale regarding this is that the gathering of information about government officials in a form that can be readily disseminated to others serves as a cardinal First Amendment interest in protecting and promoting the free discussion of governmental affairs. So, a lot of people are arguing, well, hey, recording is an expressive activity. And the courts have said, yes, that's correct, but it is fundamental to the holding of local government officials accountable, right? It goes hand in glove with First Amendment activities. So, having said that, I noted that most of the jurisprudence on these First Amendment audits, and I shouldn't say First Amendment audits, the recording of public officials involves the recording of police. And so long as, and there have been some states and some localities that have looked to kind of codify how close individuals should get to law enforcement when law enforcement is engaged in their law enforcement activities. Clearly, nobody has a right to interfere with the police officer. And, there's been a lot of discussion and debate about like how close is too close. You might have a law enforcement officer who's, actively involved in arresting an individual, and then they have somebody come up really close to them. Obviously.
Yeah, Jet 888. I'll tell you, this guy you can hear in his voice, you can hear the way he talks. This guy is live. He's not for the loyal of the people. He is trying to limit the people. He knows it's wrong, but that's just the way it is with this guy.
That can be disconcerting to a police officer who may be in a physical altercation, to have somebody come up from behind and be filming. They can't see them. But as long as they're not getting too close, and how close is too close, I think it's up for debate. As long as they aren't getting too close, the public has a right to film police and any other public official who is out in public. So what do we mean by that? Well, let's step back here and talk a little bit about the public forum analysis, because that's really where a key component of First Amendment jurisprudence lies. There are people who criticize public forum analysis with respect to First Amendment activities. Acknowledging those criticisms, public forum analysis is still the law of the land.
What was he just talking about? I wanted to say something, but the screen's gone now.
We'll back it up a second.
Yeah, just back it up just so I can look at it real quick.
About the public forum analysis, because that's really
this one.
The slide before this one?
Yeah. Because okay, maybe it was something he was talking about. Never mind. Just keep going
goes
forward.
Hand in glove with First Amendment activities. So, having said that, I noted that most of the jurisprudence on these First Amendment audits, and I shouldn't say First Amendment audits, the recording of public officials involves the recording of police. And so long as, and there have been some states and some localities that have looked to kind of codify how close individuals should get to law enforcement when law enforcement is engaged in their law.
That's what it was.
I know that a lot of people are worried about Florida's 25-foot rule, but a lot of states have tried it. A lot of municipalities have tried it. They all got shot down by the United States Constitution and the Supreme Court. And I don't suspect Florida to be any different. What do you think, bro?
Yeah, well, we know the law in Arizona was repealed or shot down. That was only 8 foot. They passed the law in Indiana for 25 foot. The last I saw, because I was just looking into this last night, I was talking with somebody. Last thing that I know of is the federal judge, I think September 26th or 27th of 2024, um, put a temporary injunction against them enforcing that law in Indiana until it's obviously litigated. So that law is not being enforced in Indiana. The law that they passed in Louisiana, I know that there's a lawsuit now with 6 media companies that are suing over the law. And last I heard on that, the federal judge was hearing oral arguments, I think December 16th or 17th. And I don't think they have a ruling yet in that case for an injunction. But yeah, these things, these laws, that there's a lot of issues with them. Like this guy's trying to, tell the government how to get around. But unfortunately, there's no getting around, what is the First Amendment. You know what I mean? Like, listen, we all know that this shit's a lie, right? All this, the dream, the freedom, all this shit they feed us is a freaking lie, right? But they have to continue the illusion, right? Because if everybody wakes up, they're screwed, right? So they have to continue the illusion. They have to continue the elections. They have to continue acting like, at least on the surface, that they care about our rights. Now, what happens in the courtroom and stuff like that, that's been shoved under the rug for so long because there hasn't been platforms for people to get out there and express their stories to other people. You know what I mean? So you never knew, you lived in Florida, you never knew what was going on in Oregon. You know what I mean? You never knew how many cops were out there violating citizens' rights on the streets every day. You'd hear of the most egregious examples, but I mean, as we all know, there's hundreds of examples every day across the country, right? So now with the platforms, now we're seeing it. And if they try to shut that down, then that's just an indicator to even the sheeple that the illusion is not real. So they have to walk a fine line to keep the sheeple in a stupid state, right? To where they just don't care. They're just looking to get paid and feed their families and drink a 6-pack of beer with their buddy on the weekend while they watch the Jets lose again. You know what I mean? So
And we all know, you guys in the chat, you guys ain't the sheeple because you're here getting educated on these government officials, getting educated how to violate our rights.
there you go.
Disgusting.
Enforcement activities. Clearly, nobody has a right to interfere with the police officer. And, there's been a lot of discussion and debate about, like, how close is too close. You might have a law enforcement officer who's, actively involved in arresting an individual, and then they have somebody come up really close to them. Obviously, that can be disconcerting to a police officer who may be in a physical altercation, to have somebody come up from behind and be filming. They can't see them. But as long as they're not getting too close, and how close is too close, I think it's up for debate. As long as they aren't getting too close, the public has a right to film police and any other public official who is out in public. So what do we mean by that? Well, let's step back here and talk a little bit about the public forum analysis, because that's really where a key component of First Amendment jurisprudence lies. There are people who criticize public forum analysis with respect to First Amendment activities. Acknowledging those criticisms, public forum analysis is still the law of the land, and it's how everybody, in my opinion, at this point, should at least approach dealing with First Amendment audits. So I want to spend a few minutes here going through public forum analysis. And generally what we have are three types of public forums or fora. We have the traditional public forum, we have a designated or sometimes referred to as a limited public forum, and then finally we have those areas that are non-public forums or fora. And so let's dive into those very quickly. First of all, what is a traditional public forum? Right? It is those areas that are held in trust for the use of the public and have been used for purposes of assembly, communicating thoughts between citizens, and discussing public questions, right? And the common areas are streets and sidewalks, parks.
I'm gonna call bullshit right now. All right, we're gonna tell these people the fucking real deal here, right? So, this traditional public forum, right, where it's been held immorally from time out of mind for public speech, that's a bunch of bullshit, right? Because, and on my community tab, I posted, it was probably a year or two ago now, but if you look, you'll find it. It's the history of the public forum doctrine, and one of the first cases, the first case that had to do with this issue was in 1897 in the Boston Commons, the same Commons that Glick was in. But it was 1897, and a gentleman wanted to practice free speech in the Boston Commons. And the Supreme Court told him that the state wasn't obligated to provide property for the citizen to do free speech. So, when these trolls say, why are we fighting for rights we already have? A lot of these rights that we have today have been fought for over the years, right? This isn't, freedom and rights, especially these kind of rights, because we're talking about civil rights, right? We're not talking about natural rights. I know a lot of people get confused because the Declaration of Independence mentions natural, unalienable rights. And then we have the Constitution, which talks about our civil rights and civil liberties. So they're two separate things. And a lot of times these guys, will confuse us, like this guy's trying to do with the government traditional public forum, which is all about regulating speech, right? It's regulating expressive activity. All of the landmark cases, Tinker versus Des Moines, the Kokenda, which is on the post office property, the Hare Krishna one, which is in the airport, the Perry Education, all these things, Adderley, all these public forum doctrine landmark cases all deal with speech, expressive activity, protesting, right? And even then, right, because when you look into it, even then, there's two cases. Tinker versus Des Moines, and there's another one. I think it's Brown v. Louisiana, but I could be wrong on it. But they're both SCOTUS cases. Both of them were dealing with First Amendment expressive activity in limited and non-public forums. Now, Tinker versus Des Moines was in a school where the kids were wearing, I believe it was a black armband, and this was right around the late 60s, 70s during the Vietnam era, I believe, and they were wearing a black armband, and they were allowed to protest, right? Because this was a silent protest, and they were allowed to do it. SCOTUS said that they were allowed to do it. So it not all expressive activity has totally been banned, even when they throw up this public forum doctrine, right? And the Brown versus Louisiana, if that's the case name I'm thinking about, but the cases were a bunch of young black men and women went into a library and they had a sit-in, right? And the Supreme Court said that they were allowed to do that. So again, there's instances where even expressive activity has been allowed in these forums, but when me and Dan go in there, we're not expressive, right? Like in Florida, you're allowed to secretly record anywhere the public's allowed, where there's no expectation of privacy. It's not against the law. So if I've got an audio recorder in my pocket, that's not expressive. It gets no more expressive if I take that audio recorder out of my pocket and hold it in my hand, right? I'm not trying to express anything. I'm not demonstrating. I'm not protesting. I'm not trying to pass a message or pass an ideal or anything of that nature, right? I'm gathering information, right? I'm gathering content, right? they're butchering the English language by saying that me gathering is expressive, right? It's they're two different things. They don't go together. I'm sorry, Dan. I'm going rambling on. We got to finish watching.
No, that's why we're here, man. We got to accept these people straight. I mean, these people, they try to take our rights, and we're here to point out how they're trying to do it. And the only foothold that these government officials have on stopping us from filming inside city halls, as they're trying here, is literally trying to use expressive activities such as like protests. You know what I mean? Like a protest, you're holding a sign, you're yelling loud. You can see how that would distract, town hall. You couldn't function. But for them to piggyback the camera, and that's exactly what they're trying to do, and what we're exposing today. So we'll hear more about their BS and government traditional public forums. Wait till they get into the other forms.
City Hall and Plaza Steps, the Village Square, the Town Square, those public areas that, again, are generally where most people would think that they have a right, and not just think, but that's where they've traditionally exercised their right to talk to their fellow citizens, to proclaim to government officials, their thoughts, ideas, their speech. So obviously you can impose certain regulations here. If we talk about streets and sidewalks also have other uses, and local governments can adopt time, place, and manner regulations that provide for the accommodation of those other uses, right? Streets for vehicular, bicycle, pedestrian traffic, sidewalks for pedestrians to use, parks as well. I mean, parks have other uses, recreational, athletic uses. City Hall, Plaza, and Steps generally, for people to get in and out of the municipal facilities to conduct municipal business. So,
as this guy talks about traditional public forums and where you can use free speech in that, just think about how many Jeff Gray videos we've seen where he's on the traditional public forums, and this government's still trying to regulate him out of there somehow. And so these government officials, they're slime.
You can adopt regulations, but again, they need to be pretty narrow, and they need to be content neutral, and they need to be reasonable in the context and the history that these locations are reasonable, are traditional public forums. You'll note what is missing from here is that the interior of a city hall, like there's nothing in any case law that really states that city hall offices, village hall offices, DPW garages are traditional public forums. There just aren't. There isn't any case law. There's no precedent. There are no court decisions where the courts have come out and stated, hey, the public has a right to be in here to exercise their First Amendment rights. There's an important exception to that, and I'll talk about that. Let's.
So where he's talking about the using your First Amendment right to traditional public forum and things like VFW posts where you go into the highway department. Yeah, I agree that most people wouldn't go to the highway department to exercise their First Amendment right of speech, limited by the public forum doctrine. But if the press wants to go there, which is separate from freedom of speech, what as long as it's open to the public and you're not crossing any lines, what he's talking about doesn't even line up to what he's talking about.
Let's move on. We'll talk about designated public forums. What do we mean by that? Right? A designated public forum, or fora, are areas that are not traditionally open to the public to assemble and to debate and to engage their government officials or other individuals. But those are areas that the authorities nonetheless have intentionally opened up to public discourse. All right? That would be referred to as a designated or limited public forum. And examples of this are obviously meetings of public bodies, and these areas are designated public forums because of the open meetings law, right? Now, I will note here, and this is an important exception, when you have a designated public forum, there can be limitations to the speech or expressive activity that is allowed. And with respect to the open meetings law,
Dan, hang on for
it
1
allows
second.
the public.
Now, to remind you, they are talking about New York open meetings law. I'm not sure everyone is from a different state, but New York open meetings law mandates that you can be recording it. So what he's trying to say here is that if you limit it, you can't do it during the open meetings. It's. But go ahead. What you had to say.
Well, I just wanted to point out the fact that when we're listening to these people talk, or even when we're, reading what they're writing, you'll notice, okay, so like he's talking about the designated public forum, right? But look at the examples that he's using, right? They're all expressive examples. Meetings of public bodies, public hearings, municipal row or public land for the posting of signs, right? Again, this is all expressive activity, right? None of this stuff, none of these examples that you'll ever read for these designated public forums says restrictions on recording. They won't say it, right? None of the public forum stuff talks about recording at all. There's no landmark cases dealing with recording in the public forum doctrine. And the only cases that they can come up with that they do, like the Evers case or the, gosh, there was another one, but both of those instances in both of those cases where the gentlemen were located or wanted to be located was a place where the general public wasn't allowed. See, the whole crux to the matter is that the press and the public are one and the same. So if the public's allowed, the press is allowed. And the Supreme Court has said this numerous times. Brandsburg v. Hayes, Pell versus Pecunior. Gosh, there was another one too somewhere in there. But 3 times. Oh, Hutchins versus KQED, where Justice White said that the Constitution assures that when the government opens its doors, it opens its doors to the public and the press equally, right? That's what the Constitution assures us, right? Now let's examine that with the 11th Circuit case of Smith v. Cumming, right? Where they said that we have a right to watch our public officials on public property when they're dealing with matters of public interest. Okay, what public interest would the reporter find from the public official walking from the parking lot from his car into the building? What matter of public importance would we capture then? So we have to read everything and understand everything in context, how it all works together, because obviously, if the public and the press have the same right of access, like the Supreme Court says they do, and the 11th Circuit says that we're allowed to watch the government officials on public property while they're dealing with matters of public interest, it obviously doesn't mean that we can only watch them from traditional public forums. It's just stupid, right? Now that I put that together, everybody can see how stupid that would be, right? I'm sorry, Dan, let's go on.
To attend and observe and even record, the open meetings law does not impose a mandate or obligate public bodies to allow the public to comment. That's not a requirement of the open meetings law. However, we do have public hearings, and the express purpose of a public hearing is to allow the public to come and comment or testify on a specific subject. But again, even this is not unfettered, because let's say you have a public hearing on a municipality's proposed local law. The municipality can limit any comments to that topic, right? So it's not a full-blown open free-for-all of a traditional public forum. You can have limitations in this context as far as public hearings. Another example of a designated public forum is the municipal right-of-way. Municipalities, many have opened up and allowed that unimproved portion of their streets to be used to posting of signs and placing of signs, but you're not required to. That's municipal property. Same thing, you can have it for parks. I mean, some parks, generally, I wouldn't recommend allowing the public to place their signs, temporary signs, on parkland, but you can. Once you do, though, however, be prepared to allow all signs in your public parks. Okay, so those are just some examples of designated public forums. While the meetings of public bodies generally occur in the city council hall chambers or the board of trustees hall meeting room, it's only that limited area in the city hall or in the village hall that is a designated public forum. Okay, you don't see the in this list either the fact that, hey, the village clerk's office is a designated public forum. I mean, you can make it a designated public forum, but nothing in state law, nothing in federal law makes those offices designated public forums. All right. So if it's not a traditional public forum and it's not a designated public forum, everything else falls into the category of not a public forum. And non-public forums, people don't have really any special First Amendment protections or rights in non-public fora. They might have First Amendment rights on their own private property, which is also a non-public forum, but that's their private property. But all of those other public properties that are not traditional public forums or designated public forums, that's going to be a non-public forum. Okay. So with that said, it's important to understand that this issue has actually been litigated, and there have been a lot of cases about publicly owned property that the courts have recognized. Just because it's publicly owned doesn't mean that it is a traditional public forum or designated public forum. One of the seminal cases here is Cornelius versus the NAACP. And there, the court recognized that a principal purpose of the traditional public forum is the free exchange of ideas, right, in that case. But the court noted that the government does not create a public forum by inaction or by permitting limited discourse, but only by intentionally opening up a non-traditional forum for public discourse. I'm going to say this again. This is really important. Again, this is a Supreme Court case, the highest court in the state of in the country. The government does not create a public forum by inaction or by permitting limited discourse, but only by intentionally opening a non-traditional forum for public discourse. That case has been cited repeatedly by the Supreme Court itself, but also other lower courts. The other thing to note here, and this really is important as well, this is a case of Minnesota Voters Alliance versus Mansky, and if you need the exact citation, I can provide it to you. It'll be in the article that is going to be published in our Municipal Matters magazine. The court recognized that the government, like private entities, the government has an interest in preserving its property under its control for the uses which it is lawfully dedicated. And we should recognize, like, local governments do a lot of things, right? They provide services, they represent their constituents, and all of the facilities, all of the properties that they own for the local government owns, you know, a good percentage of it, if not most of it, is not designed nor intended to be a traditional public forum or even a limited public forum. I mentioned earlier DPW garages. I mean, obviously, most people would think or recognize, well, that's not a place for the public to go where we've got heavy equipment and machinery going around. We might have a salt shed. But we've seen some of these First Amendment auditors even go to those types of properties.
Most of those DFWs are, you know, they all have offices to get permits at. There's a lot of reasons you go there. I mean, a lot of corruption can happen there. I mean, just think of what could be discovered there. I went to one, and they did real nice. They gave us a whole tour of the place. It was great for the public to see where the tax money goes. So there's plenty of reasons to go to a highway department. There's tons of reasons to go there. Plus, you know, those guys are tyrants. Do you have something to say, Rogue?
I couldn't agree more with you, buddy. I've gone to them as well. You know what I mean? Like,
I've seen good, bad, and the ugly in them.
Right. Like, how does any government agency get a pass, right? Like, is there some government agency that somehow is not out there mishandling money? I've never seen that unicorn. Let me lasso that.
They were
Let me lasso that unicorn.
They don't have the ability to order tires on the public's dime and throw it on their personal vehicles. Come on, right? They would never do that.
No.
Corruption that doesn't exist in the highway department. That's probably one of the worst places. Those guys, they probably steal signs, posts. You probably go in their backyard and they probably have a clothesline post with all the fence posts from the.
Exactly. You go in the man.
They probably
man
got street signs with their name on it, built from the county office. Come on.
Yep. All in the man cave.
I got one coming up with the dog catcher. This guy be like, they don't need to be a dog catcher. She violated my First Amendment rights, and we took care of that.
Yeah.
So this guy here thinks there's no reason to check up on government if there's, depending on the form. Come on.
Yeah, that's what he's basically saying. That's what all these guys are basically saying, is that we only have the right to record our public officials from outside of a building. Like, how idiotic is that? You know what I mean? Like, and literally, it doesn't matter if they have a regulation or not, right? Because I've proven this before. There's a Pasco County has a regulation, no recording in the DMV. Well, I went in there with my little hidden camera, and I walked around with my clipboard, and I stood there, whatever, and acted like I was writing down people's information. You know what I mean? And I came home and I published it. That was that, and guess what? Nothing happened, right? They didn't charge me with anything, So if we could do that secretly, then we can do it openly, right? I mean, it just makes sense.
Yeah. A government agency that doesn't need watched after. Let's hear some more of this nonsense.
Yeah.
Obviously, municipal jails are not really designed and
municipal jail shouldn't be checked out. Didn't we just see what happened in New York's municipal jail? Clyde, New York. I might remind you, Clyde, New York's mayor is on this board right here, where that prison beating happened, that we all were just absolutely just disgusted by. The most vile thing, one of the vile videos I ever seen. We don't need to watch a jail. Come on.
Tended to be open to the public. And those have been locations for First Amendment auditors as well. And so if we think about this, like, what is this property being used for? If we have municipal offices, generally that's those are locations to allow public officials, public employees to perform their jobs, to provide water and sewer to their residents, to help their constituents pay taxes, to come in and deal with code enforcement issues. So there's a whole list of services that municipalities provide that are clearly, they need to be able to do that without having interference from individuals just walking through their offices, right? We also have security concerns of our members, and I'll talk about that in a little bit too for those locations. And so this court as well noted that there's nothing in the Constitution that requires the government to freely grant access to all who wish to exercise their right to speech on every type of government property without regard to the nature of the property or to the disruption that might be caused by the speaker's activities. Okay, so important to note those two cases. The next case I want to note, and this touches upon in the next two cases, specifically recording within municipal facilities. And this case was a Pennsylvania case. So this is not a federal case. This is a Pennsylvania state case. A defendant was convicted of trespassing for filming in a police department lobby. And I will note here that the lobby is of a police department, generally open to the public. It's an area where people can go in for a variety of reasons: to meet with a police officer, to file a complaint, to see how an investigation's going on, to see about one of their family friend individuals who's been taken into custody. In this instance, the police department had, even though it was open to the public, they had posted no filming, and the court recognized that, hey, this is not a traditional public forum. Just because it's open to the public to come in and conduct business there does not mean that everybody has the right to come in and film in that location.
I don't know why this guy is advocating to New Yorkers, police departments to try to. He's going to quote a law in Pennsylvania here and try to advocate to police departments in New York. Any New York police department that thinks they're going to keep the no recording in the public lobby up in New York, it's already been struck down. New York City's has been struck down. It's on an injunction and stay right now. And only Sean from Long Island technically is allowed to go there and do this, but for now, but eventually it's going to be one. The Right to Record Act in New York opens up them lobbies to recording above First Amendment protected activities, is what the federal court found. So the fact that we took these signs down, and as a matter of fact, we used that case law to take the signs down here in Cheektowaga, New York as well. But that case law and that Right to Record Act here in New York is not going to block police departments from being able to keep our cameras out.
There's that the court recognized and realized that the right to record police is not absolute, and it is subject to reasonable time, place, and manner restrictions. And they cited these other cases. Important to note there, right? Now, I will note these other cases really dealt with recording police out in the public on the streets, and that's really a separate category there. So I'm not focusing on that, and if that's an issue we can have or discussion we can have at a later date, recording police on the streets. I'm really focused on recording within municipal buildings, municipal offices. Another case that everybody should be aware of, and this is a federal case. This is a federal district court decision, so it's not a circuit court of appeals decision, but it is a federal case. In this instance, the municipality adopted an ordinance, and I'll talk about the difference, importance between adopting a regulation or just a rule regarding recording in your municipality. But I want to stress that as I talk about this case a little bit. In this case, the municipality adopted an ordinance which prohibited recording without the consent of the individuals being recorded. All right. So because there may be other people in City Hall, Village.
This guy's audience is the elected officials of your town here in New York. He is talking to the town municipalities, trying to convince them that if they want to, limit the free speech or the camera of the free press, he's trying to explain how to do it in the ins and outs of this seminar. So he's talking to the mayors and the lawmakers of New York.
Hall, who are there to conduct business, right? I mean, that happens all the time. Multiple people in the office to pay their water bills, pay their taxes, file a complaint, apply for a building permit application, submit an application to the ZBA, whatever public business, to meet with a local official. So it's not just public officials and employees who are there who are concerned about this. And once again, the court noted that the government, like any private landowner, may preserve the property under its control for the use to which it is lawfully dedicated. And again, I'm stressing this. What is the lawful reason for coming into your city or village hall? It's to pay your bills. It's to conduct that business. It's not a traditional public forum in that respect, right? It's a workplace, it's a place of employment, and it's a place where employees, the municipal employees need to be able to conduct their business, and the government has an interest in facilitating that for those employees. So the court noted here that the government has, as a result, the right to exercise control over access to the government workplace in order to avoid interruptions to the performance of the duties of its employees. This ordinance, right, in this case, placed reasonable restrictions, the court found, on recording at City Hall, given its purpose and context. And I will note, right, when you're regulating, even though this isn't a traditional public forum, the court was still looking at this as any time an individual makes a claim or an assertion in a court case, that a regulation impacts their protected First Amendment activities, the courts are going to sit up and they're going to look at this and they say, hey, you know what? Here we have the governmental interest in providing a workplace where the city employees can conduct their work, and the restrictions they imposed are reasonable, given the purposes and context, and the purpose that the city hall is to conduct. The purpose of city hall is to conduct legitimate public business, right? The court found that they could not find that the restriction on unconsented recording is unreasonable considering City Hall purpose and those circumstances. So the court went on and they cited, and this is the first case I noted, the Cornelius versus NAACP case from almost 30 years earlier, 25 years earlier. As the Supreme Court noted, restrictions on limited public forums need not be the most reasonable or even reasonable limitation. So this is one of the keys here. Because it's not a traditional public forum, I mentioned the standard at the very beginning. If this was a regulation regulating speech in a traditional public forum, or on somebody's speech on their own private property, the standard would be that you would have to justify it with a significant government interest, and it would need to be narrowly tailored. Because City Hall, and until a court determines differently, because those City Hall offices are not traditional public forums or even designated public forums, that standard doesn't apply. The standard that the courts are going to apply is kind of like this reasonableness standard, all right? It's not a compelling government interest, it's not a significant government interest, it's not a narrowly tailored standard. It is a reasonableness standard. So what does that mean for local government officials going forward with respect to this? The first thing I should say, and is it necessary that you adopt a regulation? Is it necessary that you restrict or prohibit filming within your offices? I leave that up to you. There are many municipalities where they're not going to adopt this restriction. They're not going to say that people can't record in those places in city or village hall that are open to the public. Okay. Because, they're just not going to do it. They don't want to, like, hey, what do we have to hide? It's not really that intrusive. They don't have concerns, security or invasion.
Right, and they don't want to get sued, moron.
Of privacy issues as well. They just don't want to pick the fight. And many of the communities, if you'll see the videos, and for those communities that don't overreact or don't have a restriction, frequently one of two things will happen. One, they don't even get posted online. The videos don't ever get posted online. Or two, if they do get posted online, these First Amendment auditors, they will give them credit. They'll say, hey, we think this is good. We think they handled this properly. And you'll see in the comments under these YouTube videos, and I thought about sharing some YouTube videos. I'm like, you can find it yourself if you want to. You could spend a whole.
The reason he didn't share those videos is because he's for the regulations. He's for limiting it. And you know where this guy's hometown is, guys. He lives in Syracuse or Schenectady. And you know what happens in Schenectady, New York. There is a mayor's executive order who's also on this board and limiting the speech of the free press.
The whole day going down that rabbit hole. But I thought I didn't think it was necessary for today. But you'll see that people are like, oh, good for that local government official. Look, good for that city or village or town or county or whatever it is. So it can have that impact as well. But if you want to restrict, then what do I recommend? First of all, I recommend that you have the local legislative body. That's the entity that's generally responsible for establishing the policies regarding how people use the municipal facilities. Have the local legislative body, the city council, the village board of trustees, adopt an official policy about recording restrictions, right? Have them adopted and put them in writing, okay? That's the first thing. In addition, not only recording, but you should make it clear where the public can and cannot go in your facilities. Not everything in the municipal facility, not all publicly owned property is open to the public, or should be open to the public for that matter, right? You have security concerns, you have safety concerns, you have liability concerns, municipal.
You got government employees robbing the public concerns where they're going to get caught.
Municipalities need to, you have records that are within your control, and the public shouldn't have access to those, right? You don't want to have people coming in that could just
check the credit card statements of the mayor,
take records and leave. That's a problem. So the public's access to your facility should also be addressed, whether or not you restrict recording in those public areas, right? These regulations, the access regulations and the recording regulations, should be posted. Those two things. I mentioned this earlier. Adopt an official policy, post signage, train your staff. Okay. So how do you adopt these restrictions? Let's say for those of you who are on this webinar this morning and you do want to restrict recording within the municipality, you can do it one of two ways. You can do it simply as rules of the use of your property. And any city or village, any local government may adopt rules regarding the use of its property by resolution. It does not need to be adopted as a local law for cities or villages. It doesn't need to be adopted as an ordinance, cities, if you still adopt ordinances, although you can. And whether or not you adopt it as a rule by resolution, saying, hey, we are not going to allow recording in our offices, again, except if it's the city council chamber or the village board of trustees chamber, and it's a meeting pursuant to state law, open meetings law, you have to allow recording in there, right? But for every other place, if you say, hey, we're not going to allow that, you could do it as a rule, as a resolution, no problem.
No,
you can do that. Totally
no,
reasonable,
no,
not a problem to restrict recording in those
only
areas.
scumbags do that.
What is the difference between adopting as a rule and a local law? Well, first of all, it's easier to adopt it as a rule. If you're adopting it as a local law, then you would have to follow the procedure under Section 20 of the Municipal Home Rule Law. It would have to be introduced. It would have to be aged. It would have to have a public hearing that's held on notice. You have to file it with the Secretary of State's office. But
that's why he went with rules first, right? You see that? He's like, yeah, you
He
can
wants
put
the
it
easy way out.
right. You can put it as a rule of your building. Well, the funny thing is, and I swear,
rules bring back to that point where he said, make sure you can enforce your rules. Because how many times have we got a sign. I'm like, nice, do something about it.
Yeah, right. That's a pretty sign. Where'd you get that printed at, Kinko's?
Laminator law, we call that.
Yeah. But and here's the beauty of it, because I really hate to say this, but this guy is just making municipalities lose money, right? Because anybody that listens to this idiot and puts these rules or regulations into place, now the municipalities open itself up for First Amendment lawsuits, right? Because you're restricting someone's First Amendment rights. And even if they don't, the people suing them don't win. I mean, if you get hit by a barrage of lawsuits, it could bankrupt the city, even just fighting it, not even losing them. So, and I'm going to test that out as most people already know. Easily, South Carolina passed an ordinance, and I told them the night that they passed the ordinance that I was going to sue them if they did, and they went ahead and passed it. And now I'm suing them. And they tried to get the case dismissed, and the magistrate judge said, I don't think so. And we're waiting on the district court judge to give him our opinion, but I don't think he's going to go for it either. So that'll be the first case, hopefully, on the books about a city passing an ordinance. And after that, I'm just unleashing them down here in Florida, because there's a lot of chuckle fucks down here that did that Punta Gorda shit and are trying to restrict rights down here. So I think
it's an Orlando City Hall one. You get thrown out of trespass for video recording inside there.
Yep, Orlando City Hall, West Palm Beach City Hall,
Schenectady in New York is the only one I know of in New York.
Yep. So and anybody literally, that's auditing or has some kind of outlet where they can show that they're producing like some kind of content for dissemination for the public, can sue these people and say that without even having to go there. You know what I mean? Like, all you have to do is say, yeah, I would violate that ordinance because I want to do a story on the mayor about, whatever, uh, you know, corruption, whatever. And that it's likely that they would prosecute you and that you would be harmed because of that. And that's pretty much a suit right there. So once they pass those laws, and municipalities don't have qualified immunity like the officers do, as far as violating civil rights go, they have their own, immunity, but
He's
not for.
he's gonna talk about that on this a little bit.
What's that?
We'll get to hear what he has to say about um, immunity for municipalities. He's going to touch on that in a little bit.
All right, cool. Let's hear it.
But one of the benefits of adopting it as a local law is that you could then make it impose your own penalty. You could say, hey, if anybody violates this, it shall be a violation.
It goes back to the rule. It's not really enforceable.
Or a misdemeanor, because pursuant to Section 10 of the Municipal Home Rule Law, local governments have the ability to make violations of their local laws, violations or misdemeanors, subject to a fine or even jail time, right? So you could impose your own penalty. If it's just a rule regarding the use of your property, then you're enforcing it as a trespass infraction, which I'll talk about in a second. And so that's really the difference or benefit between those two. I have a question here, and by all means, again, use the Q&A dialog box if you have any questions. Daniel asked, we posted areas that are not available to the public. The courtroom was not part of that, and we had a homeless person come in and sit in the courtroom. He was there for quite a bit. We asked him to leave, but were we allowed to ask him to leave? Courts are an interesting challenge. First of all, as a general rule, the courts are not the jurisdiction of local officials. The courts are the little fiefdoms of the judges themselves. Okay, the courts are the fiefdom of the judges themselves.
This guy said trip. He's like, courts are a difficult issue to get around people's rights. It's this real slime ball lawyer.
And first of all, Office of Court Administration, it provides rules regarding the use of the courts. The other thing is that maybe if you use a courtroom for other purposes, you don't want people in there, or when court's not in session, you should really consult with your justice. If this is a village and it's a village justice court, or if it's a city court, again, the Office of Court Administration and the courts are going to deal with this. A couple other questions. Hopefully that answered your question, Daniel. Somebody asked here, where does a municipal public library fall into this? And the answer to that is, well, first of all, I want to double check. I'm not aware of any public libraries that are their own unique beasts, but they also have their another public purpose, in my opinion. But I want to do some searching on this, so don't quote me on this. With respect to public libraries, you could prohibit or restrict recording within the public library as well, because again, it has another purpose. And it's not a traditional public forum in that context. When we think about traditional public forums, we think about where people can go in and, they can.
Remember, as he talks about these public forums, folks, he's talking about free speech. He's not talking about the free press. Two different things. They're trying to link them together, and that's how they're trying to jack our rights.
Start talking and like, hey, I'm going to.
Hold on. Yeah, I want to touch on something real quick. And if people want to write it down or come back later and grab it up, they're more than welcome to it. But the First Circuit just had a case last year. It was Berger v. Gloucester School Board, 2024. And basically they said that they were that they had discussed what was public spaces, quote, quotation mark, public spaces in the Veritas case that was in the First Circuit. And they went over it again, and they said parks and plazas and all that other stuff. But then they said other inescapable public places, like where Ayacabuchi was at. Okay. Now, Ayacabuchi versus Bolter is a First Circuit case where a gentleman was recording in a public meeting. The meeting had stopped and people were moving out into the hallway. He was out in the hallway and he saw these commissioners, and he thought that it was like an impromptu startup of the meeting there because there was a guy that was late getting there. So he started recording, thinking that they were still conducting, committee business. And a police officer came over to him and asked him to stop recording and such and such. Anyway, he got arrested for disorderly conduct, went ahead and sued. And the court said that because he was in a public area, he was exercising his First Amendment right, that the cop had no authority to ask him to stop. Right. And they went into pretty good detail. It's an excellent case to read, but they say in there that a cop is not a law unto himself. He can't just give you an order that's unlawful and then arrest you when you don't obey it. Is not verbatim what they said, but pretty much the gist of it. But it's pretty harsh. And in this other First Circuit case, when they said other inescapable public places, they were talking about this hallway, which was in City Hall, which, according to this guy, is a non-public forum, and you can't record in there, right? But the First Circuit's already said that, yeah, that you can record in there. So that's already on the books there. So I just wanted to point that out, Dan, in case somebody was wondering about that particular issue.
All right, back to the rights jacker.
Express myself. I'm going to exercise my First Amendment rights to speech. And clearly public libraries have a whole host of regulations that say, oh, no talking, no disrupting other people, because people are there to use the library for other purposes. And I think recording could be restricted in libraries as well. I'd want to do a search on that specifically, though, in case law. Daniel has another. It is used for the board meetings as well, generally as part of the village hall. I would say if it's a common meeting room, then absolutely. When it's not in use, you can say, hey, nobody can enter in here, right? Why did the public, it's not open to the public. You have an interest. This goes back to Daniel's question about this. He called it the courtroom, but it's also it's also used for other purposes. And that's actually very common to have rooms that are used for multiple purposes. That room is a designated public forum, right? For your meetings and only during your meetings. When it's not being used for a meeting of a board of trustees or a meeting of the city council or meeting of the planning board or ZBA or whatever public body that is subject to the open meetings law, then it's not clothed with that designated forum status. I hope that answers your question.
The thing he's talking about is like the meeting room. Right? The meeting room is known as the people's chamber, where the people get to get heard to their government. Right? He also talks about laws saying that public comments aren't really necessary. And then he talks about these rules and enlisting these rules. Let me make it clear. The only mayors and the only governors or, inciting these rules of any sort are tyrannical ones. They're ones that have something to hide. They don't want to get caught. Every single one of them. Doesn't matter which aspect of that you're looking at. This guy is here to advocate for their cover-ups is pretty much what this is all about, because no mayor I've ever met that I went to and said, hey, can I get a picture of the meeting room? They're like, no, it's not open to the meeting. I'll tell you what, that audit, when that happens, and it happens, the whole audit's like that. The whole government system is set up corrupt and like trash, and that's why it's important for us to be able to get in there with a camera and expose that, because what a government for the people is happy to show off their meeting room and stuff, but like this guy's trying to limit the meeting room. Like, really? Like, what are they trying to hide? Why do they feel that this government property, government owned property? See, government doesn't own property; it's public property. It's either open to the public or it's not. There's only two types. The government doesn't own any of it.
very quickly here, and then I'm going to move on. As a follow-up to OCA issues, some government buildings may also be a courthouse or showed county office buildings. New York State court rules prohibit courthouses. Yes, they do, and it's in my article, and it's in this slide. It's near the end, and we'll talk about that. To the extent that part of the facility is used, OCA has its own rules. Now, you might have combined facilities, and so maybe all of the municipal facility is not subject to OCA's restrictions, but it may be clearly that parts of that facility are subject to those restrictions. I'll talk about that in a second. All right. So let's move on here. It's the very next slide here, right? And this is one of the things I point out. If somebody comes in and says, "Hey, it's open to the public, so I have a right to record," my recommendation is, and if you're restricting recording, be prepared. Be prepared. And the way you be prepared is train your staff. I also have some other recommendations in a second. But here are two examples, and these are important examples of areas that are open to the public. And in fact, there's really constitutional protections that allow the public to go in and observe court proceedings. And yet New York State expressly has in its regulations that photographing, taking photographs, filming, videotaping, making audio tapes, or broadcasting, telecasting within a courthouse, including any courtroom, office, anywhere within a courthouse, is forbidden unless permission of the chief administrator of the courts is given, right? So we have this regulation where the courts themselves have identified a non-public forum that is open to the public. And I think that's a hook to hang your hat on. You say, hey, wait a second, if the courts can close off or prohibit or restrict filming in the state courts, and again, we're talking about places that are more public as a general rule than the offices of a city or village hall, then that's a feather in your cap with respect to defending this. Likewise, the federal courts also prohibit photographing or broadcasting, except as otherwise provided by statute. The court must not permit the taking of photographs in the courtroom during judicial proceedings. We have this specific provision in there, notwithstanding the fact that as a general rule, proceedings, with very few exceptions, like if it involves a minor or if it involves security, federal security issues, they're open to the public. The public can go in and observe files, can observe court proceedings, and yet they may not record. Okay, so best practices. I can't stress this enough. I've said it before. I'm going to say it again.
First Amendment auditor's final frontier is going to be the courtroom, guys.
And I like to keep things simple. Everybody should, even if you lose this handout, that you should adopt an official policy. Even if you're not going to restrict recording or prohibit recording, have a policy about where the public can and cannot go. I think that's a no-brainer, right? And normally for most people, this would not be an issue, right? I mean, and this is another reason why, you have to ask yourself, is it really necessary to adopt this regulation? Because how often are you having to deal with these issues? I mean, really, we're only having to deal with these First Amendment auditors. And like, if that's all you're dealing with, do we need these regulations or restrictions? Having said that, I think clearly access to places where you don't want people coming in and walking around is something that you should be concerned about always, right? For security, for integrity of your office supplies and what have you, records, municipal records, you want to make sure that you don't have people just walking through offices that could have access to government documents, government files, government records. So whatever it is, adopt an official policy. Again, somebody asked, do I have a simple resolution? No, I don't. I don't have a sample resolution because it really depends on what you want to do. We might come up with something, in which case we'll put it online or we'll post it somewhere, but it's really up to you. If you want to restrict access, it would be fairly straightforward. Unless otherwise posted, and allowed, recording shall not be allowed on any municipal facility that is not a traditional public forum, or you can designate city hall, village hall, right? Whatever the regulation or policy it is, post the signage. Post signage. Recording is not allowed. Unauthorized, no unauthorized employees beyond this point. Authorized employees only. Post signage. That's a simple thing. A lot of these First Amendment auditors, they'll come on and they'll say, hey, wait a second, there's no sign saying I can't record. This place is open to the public. Where's the signage? Right? So those two things. Or
the thing you should warn these places about, if they hang a sign that says no recording, it's going to bring us in droves.
Who established this regulation? Where is this rule put down? And if you don't have adopted as official policy, then you've got to go back and you've got to argue the cases that I previously cited, that just because of inaction doesn't make it a public forum. But it's better to have an official policy in place, and it's better to have appropriate signage posted. Finally, train your staff in how to respond. Most of the videos that are online, and there are a ton of them, it's not just New York. There are a ton of these individuals going around because everybody's got one of these days, and it's really easy to use. And they'll pull out their phone, or maybe they'll have a better camera, but it's very accessible, and they'll just start walking around. Sometimes I can't say whether they're really good government advocates or not. I really can't. I mean, some of these individuals, if you look at some of the other stuff that they're posting online, it's suspect in my opinion. But having said that, we are public officials. I'm not a public official, but you all are public officials. And with being a public official comes certain responsibilities and obligations and burdens. And that is that you're a public servant. Your title, your name, your salary that you make is public information. And the public has a right to records under the Freedom of Information Law. They have a right to come into your meetings under the Open Meetings Law. And so that comes with some obligations and responsibilities. I can't stress this, so I'm reiterating this here at this point. Consult with your attorney. Best practice, is it necessary? Do you need to do this? Maybe, maybe not. I don't know. There's no shortage of NICOM members who have just said, hey, come in, record. You want to record? Sure, record. What do you need? You need an access to a record? Sure, let's go over this. And they haven't had any problems. These auditors go away again, and it's not an issue. They don't get videos posted online, or if they do.
His whole seminar should just be about that. If you treat everybody that comes in with respect and you do your job properly, doesn't matter if they're a First Amendment auditor or not, you're going to look good. Like, it's just that simple. Like, all this hour and 25-minute video of how to get rid of these people, you could sum this up in 20 minutes. Just act professional, do your job, understand that you work for the government, you have the right to be recorded in your job, and act professional. We'd all be put out of business, but instead they want to make these laws and rules and against our rights. It's insane.
No, dude, it's what's so crazy about it is, just like you said, look at all the time and money put into just this seminar. You could have made it, like you said, 6 minutes. Do your job, act professional, only call security if they try to go in restricted access areas. You're a public servant. You have the right to be recorded. Just leave them alone. Don't go away. And we post these videos online, and I did a video in Biloxi where I did their city hall, and they loved it. And the public officials that I talked to, they loved me, dude. They sat there, they talked with me, they gave me a tour, they gave me the history of the building. I made the front page of the Biloxi newspaper with my freaking audit, dude. They loved it there. You know what I mean? It was awesome. And I wish everyone could be like that. Like, they were really proud of their city and their city hall and stuff like that. And, maybe they're corrupt there. I'm sure there's corruption all around, but, it raises red flags when you do stuff like what Dan's saying, when you're trying to hide, when you're making these laws, when you're, doing all this stuff that just raises red flags. Like, I haven't looked back into Biloxi since I left there from my audit. And if no one from Biloxi reaches out, chances of me going there again maybe not that high, because I've got other fish to fry. There's other municipalities that are red flagging, ping, 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 all over the damn place. You know what I mean? So I have to divide my time. We don't have a lot of people. We got a lot of auditors in Florida, but the rest of the Southeast U.S., there's not a lot. So, once I'm out on probation, I'll be hitting the Southeast again. And there's a lot of work to be done. Dan's going to come down and help me. He's going to bring his corruption cruiser.
Zoom this in for you guys. All right, so this is a letter that I want to share. And this ties right into it here. This is the letter that was written by this guy here, John C. Welch. He is the chief administrator, pretty much county executive, the top guy in the county executive of Orleans County, New York. Now, I did a First Amendment audit there. Everybody acted professional. Everything was great. And when they tried to take me to federal probation and stop me from doing First Amendment audits, which I touched on earlier, a few of these county executives, including Gates County, was another one. But this letter I want to share with you guys. This is what an executive or a person of government control looks like when they're doing things properly. All right. So I did a audit there, and this guy, he came out, we talked, he gave me a tour of the place, and then he wrote this letter to the judge, Lawrence Villardo of the Buffalo federal court system when they were trying to take away my rights. And it just goes on here. We can read, I won't read the whole thing, but it just goes on to talk about, you guys can read it, pause it, but it just goes on to talk about, we didn't agree on everything, but we went in there and had a good time and were able to do it. But this is the part that I wanted to read for you guys here. It says here, we believe in transparency in government, and our employees are to be served the public as we provide our servants and our we believe in transparency in government, and our employees are to be serving the public as we provide service to our residents. We believe that our employees should be professional, courteous, and kind to our customers. Mr. Warmus reciprocated those characteristics and traits to our employees. Mr. Warmus, as a First Amendment auditor, allows the County of Orleans to have a third-party observer on how we truly interact with the public. This is an invaluable feedback that allows us to improve our operations and serve the public. Now, this is the type of supervisor that will never, government employee will never incite any type of stuff of that nature. He understands the value of a First Amendment audit. So I just wanted to show what a good public servant, and that'll never happen in New Orleans County. They're not going to be making any new laws anytime soon about recording in public. So it just goes to show. I wanted to add that in real quick.
People are like, oh, nice job. Yeah. I will tell you that people who, and the reason going back to train your staff, when staff is not properly trained, it results in a lot of bad things. It results in bad press. It potentially results in local officials, violating the law. It depends on how it's done and when it's done. It can also result, and there are a ton of people here where they've, when they fail an audit, and I say fail, you notice I use the air quotes, there are online trolls who will get on there and they failed an audit. And so now people, for some reason, feel like they should inundate the municipality. They should call them, they should email them, and not just saying, hey, you suck, but death threats, all sorts of vile name calling. I don't know what purpose that serves, other than to be terrible. But I can tell you that as a general rule, any municipality that fails an audit then gets inundated with emails and phone calls and some pretty vile stuff and threatening language. So, that's why you need to train your staff on how to respond. Very quickly, there's some other things I want to talk about here, and then I will get to the questions here. What are some of the rationales that you would want to restrict? Okay. So security and privacy, that's the first thing. There's somebody coming in, and that's why, again, generally police departments don't allow recording within their facilities. That's why courts, as a general rule, don't allow recording within their facilities. Local government officials have many of the same concerns within city or village hall. Somebody may be, a private individual may be going in to pay their taxes or deal with an issue or file a complaint or meet with an official, and they have a privacy concern. They don't want the public to know that they are there, and as a result, that may be an issue. Security. Having somebody go in and record the layout of a municipal facility can be very troubling from a local official standpoint. I mean, local governments, unfortunately, are regular targets of violence, more so today than ever before. And I think that's actually borne out by the behavior of many of these individuals who call in and threaten these officials as a result of their failed First Amendment audit. And so to the extent that there's video of the interior of the office about where the doors are, where's the layout of the offices, what kind of security they have in place, do they have a magnetometer, are the doors locked? All of those are, to be honest, valid concerns of local officials. And I will tell you, the courts as well are very concerned about court security. There's no shortage of incidents where we've had judges attacked, and to the extent that you have your court facilities located within your city or village hall as well, it's something that you may want to consult with your courts on in that respect. I see we've got some questions. Go ahead and put them in the Q&A dialog box. I'll get to those in a second. I will note that if you're unable to clearly articulate any reason why filming should not be allowed, that's on you, all right? And when you adopt this, if you adopt a restriction on recording within your municipal facilities, that you do also adopt or articulate why you're adopting, what your concerns are, privacy, security, what have you. Train your staff. I'm going to spend a couple of seconds here. I know this was only going to be like an hour here, but I do want to stress this. I want to drive this home. Train your staff. Make sure they know what the policy is. Do you allow recording? Don't you? Where should the public be allowed? What parts of your city or village hall are open to the public? Train your staff in that policy. If they don't know the policy, they can't articulate a response, right? How should they respond? If somebody comes in and they are violating the policy, how should they respond? When do you want them to call the police? Do you want them to say, hey, just a friendly reminder, there's no recording in here. You can see the signage posted. This was an official policy adopted by the Board of Trustees. How much do you want them to go into it? Say, hey, there's privacy and security concerns. By all means, is there any way that I can help you, right? What is their customer service response in that respect? Do you give them a couple of warnings? Like, I'm sorry, sir, I've asked you, once to comply with the regulations for the use of this facility. I would also,
sir, I told you can't have your rights here. I told you already once.
Say like, hey, have them actually maybe a note card that they would pull out and have this written down, because not everybody is used to these kind of and they can be very confrontational settings. Particularly, sometimes these individuals come in and they're very friendly, and particularly if the official's friendly, it doesn't escalate. But when you tell them they can't record, maybe they might escalate. Some of these individuals, and they're not all the same, there are a ton of these First Amendment auditors, they're doing it and they're aggressive to begin with because they are doing it specifically trying to get a bad response from the local employees or officials. And my response is, kill them with kindness. Be super polite. There's never any reason for, in this instance, to get agitated or angry. But you might have, hey, just have the policy. Hey, our board adopted the resolution, or there's a local law. We've adopted a local law that prohibits recording. Whatever it is, be able to cite that policy. Point to the signage. Have the signage posted. You might also
have your
want to
flashcard
actually
ready, Rogue.
have court decisions that support your decision in writing. Say, hey, pursuant to pursuant to Cornelius versus the NAACP, give them the citation, 1985 U.S. Supreme Court case. This facility is not required to allow recording. It's not a traditional public forum, and as such, we don't allow it here. You may want to have that, but there's no way an individual employee, as a general rule, is going to remember that in their head.
Hold on. I just want to say about Six Oaks' comment. He said, did he just recommend a government trifold? And that's pretty much exactly what he recommended. A government trifold.
Hold on, I'm making it right now. This is what their trifold is going to look like. No constitution here. You're trespassed. We're going to sell these trifolds to the government.
Yep.
This is called the free money trifold.
That's so funny.
Because you know what the Allegheny County song says, that Pemberthy's going to neuter them in court when they try this bullshit.
Yeah, man. Yeah.
The government trifold. No constitution. You're trespassed. Just that simple. Free money.
Have the staff practice this.
Haven't practiced that trifold, folks.
Have somebody come in and pretend to be a First Amendment auditor. Maybe they know that, maybe they don't.
All you mayors and governors out there watching this, my email is in the Mine Rogue, so we're easy to contact. You don't even have to pretend to be one. We'll come.
Oh, have somebody else come out. And do you record the individuals yourself? That can be controversial, but I think there's some benefit to potentially pulling out your own phone and recording it, because
Public
it gives
employees,
you a copy of what actually transpired. And so what can happen is sometimes these First Amendment auditors, some of them will put the whole video. You'll see that there's like 60-minute video on YouTube. You can see them walk in and walk around. How boring. But they put the whole thing on there to their credit. In many instances, the videos are edited. And of course, that puts you at a disadvantage. If the First Amendment auditor puts up an edited version of their video, and you think, wait, that's not exactly what happened. They're not telling the whole story. If you have your own video that you can, put up, or if it, for some reason, if it were ever to go to court, that you.
This guy sounds like he's describing the government. They're the ones that are always lying about stuff. That's why we record.
You could show in court, that would be helpful as well. So again, train your staff. Make sure they know what the policy is. Make sure they know how you want them to respond. When do they call the police? Practice their responses. So I talked about this. If you haven't adopted your regulation restricting access or restricting recording, if somebody comes in and they're recording in violation of your rules and they refuse to stop, then technically they are trespassing, because a trespass is not just, hey, they're on my property. A trespass is, hey, they're on my property and they're not.
There is case law in New York in the appeals court that says that, I don't know the exact case law, but it says that you cannot be trespassed for constitutionally protected activity.
Complying with my rules, and they're refusing to leave when I direct them to do so as a result of that.
That's People v. Leonard.
Yeah.
For New York, People v. Leonard.
Because they tried to trespass a guy for protesting on a college grounds, I believe it was.
Right. And in South Carolina, the trespassing law doesn't apply to private or public property, except I think schools, and there's another instance, schools and some other place, they have their own trespassing laws there. But for like city halls, health departments, stuff like that in South Carolina, the trespass law doesn't apply there. But I hate to do this, brother, but I gotta go. I gotta watch a movie with the fam. We're at the 2-hour mark. I know there's a little bit left, but I gotta bail. I'm sorry.
No, that's all right. I'll finish her out with the fam here. You have a good night.
Yep.
And
Yep. Thanks to
tell the family
everybody.
I said hi.
Absolutely, I will. We're gonna watch Analyze This. My girls haven't seen it, so pretty
All right.
stoked. All right. Later,
We're gonna
everybody.
finish analyzing this while you go analyze that. And
There you
you have
go,
a good
brother.
night.
All right, buddy. I'll talk to you soon.
See ya.
Later.
And everybody remember when you're in your own state, every state has its own trespass laws. There's no blanket trespass law that goes across all the states. So when you're talking trespass laws, you should really look into your own laws because some of them are better than others. Some state that on public property trespass can't be committed without a crime, and some don't. So you're gonna have to look into your own trespass laws in your own state. This guy specifically is talking about New York.
Those rules. So you would be prosecuting this as a violation of Penal Law Section 140.05. That's one option. Sometimes it can arise to the level that you have a harassment going on when it's not just that they're recording, but they go beyond that. And that's really, if somebody's just recording an individual, that's generally not going to meet the harassment threshold, right? I don't like to be recorded. I don't have a lot of hair. I don't like to look at it. I don't like the sound of my voice. Having said that, that's my problem. That's not harassment. And that's why, again, just because somebody's recording in a meeting and I'm uncomfortable with being recorded, that's my problem, not theirs. The open meetings law allows them to record in the meeting. But we have seen many instances where these individuals they've been more aggressive. Some of them will come up and they'll start asking the official or the employee, what's your name, right? Does the employee have an obligation legally to respond to that? No. And individuals from the public don't have a right to come up and start demanding things from village employees or officials. That is nowhere in the law. That is nowhere in the law. Another issue, you might be able to, they might be violating Section 195.05 of the penal law in obstructing governmental administration in the second degree. Again, these standards are fairly high, so I'm not sure they will meet that threshold, and that's one of the downsides of just putting in place a regulation. If you adopt your own local law saying no recording within city hall or village hall, then you can prosecute that local law and you don't have to rely on these other penal laws. In deciding which route to take, discuss this with your village attorney, because they're going to be the ones that you enlist not only to craft a regulation, but also how to deal with it after the fact, right? Oops. A couple of other issues here. This is the last slide. FOIL requests. A lot of times these individuals come in, they're recording, but they're also simultaneously submitting a FOIL request. They're making it verbally. You can require them to submit.
For all the users that are unfamiliar, FOIL is Freedom of Information Law in New York. It's a New York state law. That's how you get public records through state governments in New York. FOIA is the exact same thing as a federal law. Every state has its own law, and they all have different names.
Submit a written FOIL request, just as an FYI. The FOIL request, if they're making it to an individual who's not the records access officer, have them make it to the records access officer. They have to, you can require them.
This guy here is absolutely murdering the FOIL law. FOIL can be given to any member of a government agency, and they have to give it to the public access records law access officer. This guy's trying to say divert them to there. Don't even give it to him. This guy's off his rockers with his association of how FOIL really works in New York.
Them to submit it in writing. In fact, I recommend that all FOIL requests be submitted in writing, even if it's a fairly simple and straightforward one. You can't require them to use your form, but if it's a reasonably described FOIL request in writing, you got to accept it. Another issue that's come up lately is individuals have been coming in and say, hey, a FOIL request, I want this information. And they said, well, here, fill out the FOIL request. And they say, well, I'm illiterate. Fill it out for me. The first thing to note is that illiteracy by itself is not a protected disability, a recognized disability under the ADA, the Americans with Disability Act. If it is a mental or physical impairment, that affects their ability to fill out or complete the FOIA request, then you should provide them with a reasonable accommodation, and filling that out would be a reasonable accommodation. The tricky part is like, oh, well, you know, are they really illiterate? I said that's not per se a recognized disability. Do you want to fight that fight? Pick your battles, people. Pick your battles. Individuals do have and this is through the case law, really, and if this is a question or issue, follow up with me later on this. They have to make a reasonable efforts to assist the government entity in providing the reasonable accommodation. Again, do you want to fight that fight? Fill it out, go that route. Another thing to note, and I alluded to this before, you're not required as a general rule, to generate a record. However, the Freedom of Information Law does require municipalities to maintain certain records, and one of those is the name, title, phone number, and email address or salary of the officials, right? And when you get those requests, how do you respond to those? That information, as a general rule, is public information. Two caveats: phone number and email address. I think you need to be very careful about handing out phone numbers and email addresses to these individuals for a variety of reasons. Now, generally those phone numbers and email addresses are subject to disclosure under FOIA, and there are many opinions on the committee and Open Government website. The committee has long recognized, however, that there may be phone numbers and email addresses that should be withheld, because if they're made public, those numbers and email addresses could be inundated with emails, and it would overwhelm that phone number or email address, and that's dedicated for a specific purpose. So, for example, if you have an emergency number that is used for emergencies, you don't want that number out to the public, you know, so that it gets inundated with the public. This concern is a clear concern given the history that we have with respect to First Amendment audits, that when the First Amendment auditors, they will put out your phone number and email address, and you will get inundated with phone calls, voicemails, emails from all over the world, not just New York, not just the United States, but all over the world, from individuals who are upset because you failed your First Amendment audit. Or maybe you didn't fail it, but they still didn't like how you handle it. So be very careful about handing out that information. But this is what I will say. If somebody comes up to a local official and asks for their name and title, why not give it? Why not give it? It is because it is public information. It's, you know, it's one of the things that when an individual takes a job with a local government, that their name as a public official, their title, their gross salary, not their net salary, just their gross salary, not what they take home in their paycheck. Nobody's entitled to know what deductions you have, right? But your gross salary, that's all by law public information. So it's something that many.
I don't know where this guy gets off thinking that government officials' tax records wouldn't be public records. I do believe the Supreme Court ruled that Donald Trump had to turn all his over. So if that government official has to turn his over, I don't see why every government official's tax records wouldn't be discoverable. Personally, I don't know. What do you guys think?
Many officials are not comfortable with, but it's something that they do need to become comfortable with, and so they need to be trained. So that's the end of my slides. Let's go through some of these questions that are here. If you have to leave, everybody, I'm going to put share the PowerPoint one last time for those individuals who are late getting here. It's in the chat box. You can download that. We'll go through this. This webinar will be made available, but to members only. So it's only going to be in the members only section.
Members only, guys. Now it's available for everybody to see this later.
A village clerk's office has a window for the public. However, the entrance to the door.
You guys are all members of my family. You guys can have it, because you know what they did is they distributed this to the government, and it became public records.
The office is locked, so access is only available to those who have keys. Do we need a resolution identifying this area as restricted? No, again, I don't not really as a window for the public. So I'm not exactly sure. So how do people get in? You let people come in, and when they have business, again, I think.
I believe the seminar and the webinar is over. I think he's just going to go through some questions. So let's go ahead and listen to this counsel has to say. I believe the seminar itself is over. So it's another more 10 minutes left. So we'll go ahead and finish it up. But you guys, make sure you leave a comment about what you guys think of this guy.
If we go back to this case, I'm going to cite this because this is the starting point. And even if you don't adopt a policy, it's still my recommendation that you adopt a policy. But you could argue, right, that nothing in the Constitution requires the government to freely grant access to all who wish to exercise their right to free speech on every type of government property without regard to the nature.
This guy is going on about this free speech, but we're not exercising free speech. We're not using our voices when we're just video recording, collecting content for our video. That is freedom of the press. So this guy he's trying to bundle them together, and that's the way they're going to try to jack your rights, fam. Be aware.
Other issue, and this is the key too, the government does not create a public forum by inaction. So you can hang your hat on this hook, on this case, and say, hey, we don't need an official policy. I just recommend if you don't want to have public recording in there, then adopt it as official policy. Regarding this access, if you don't have an official policy, it's kind of by practice, and that's fine too. It's totally fine to have policies in place by practice. It is not recommended by the Conference of Mayors or even by the courts, for that matter, because when you have practice, that's a challenge. Thoughts on ways to ban recording in general, subject to personally communication invitation by an employee. I'm not sure what you mean by this. It's an anonymous attendee. I don't know who this is. I'm thinking of a situation where someone may be willing to be interviewed for a TV news story and needs to override the general ban. That's not a problem. Like if the municipality is inviting a television station into their facilities to record a story about some public policy issue, some development that's coming in, a regulation that they're concerned about, the budget, whatever, that doesn't open it up to being a public forum, and you don't need to have an exception to that rule, to your general prohibition against recording within the municipal facilities. Does the person have to provide their name when completing a FOIL request? Great question there. As a general rule, the answer to that is no, if they don't provide their actual name. There are a couple of caveats with that, and this isn't really.
Here's where the tricky part comes in. You don't have to give your name, but if they deny it and you have to sue them for it, you know what's going to go on that lawsuit? Your friggin' name. So that's what they do. They get around how to get your name, but no, you don't have to in New York. The only thing you have to provide is an address for them to get the information to, an email address or a physical address.
A FOIL session. You can make some inquiries about how an individual is going to use information when they submit a FOIL request, that it not be used to assure yourself that it's not going to be used for commercial purposes. So, but that's really like the only time you can make an inquiry. FOIL does not require or mandate that.
What he means there is like you can't use the information to make money off of it.
An individual provide their real name. I could give my name as Mickey Mouse. In fact, you will have individuals who will create fictitious email accounts and a fake name and submit that as a FOIL request. And there's nothing in state law that would prohibit that. And you couldn't deny the FOIL request because you suspect that it is not the person's or requester's true name. We are currently denying all personnel record FOIL requests given the current security risks. Woo! I am giving them nothing. Let them sue me. Staff here received thousands of emails. This is from Linda Kingsley in in Rochester who's having an issue. I believe that if we are sued, we will be supported by the courts. And I think this is one of the things that everybody.
Oh, snap. Did you guys hear that? Oh, snap. Laura Kingsley's going to have to. I'm writing. She just made the list. Laura Kingsley. I'm not giving anything out. I'll let them sue me. Woo! I like that video evidence of that. I'm gonna go get it, fam. That's an audit.
Should be aware of as well. Like, there currently is a significant threat to local officials from like serious harassment and threats of violence, death threats. This is unfortunately common, and I think that's something to be aware of. Can you deny based upon the fact that you think this individual is going to distribute that? That's a tough answer. Let's say, what if you're denying all personnel records requests? Let's say the newspapers come in and they make a request. It's the Democrat and Chronicle, it's the Buffalo News, it's the Post Standard, it's Times Union, it's the New York Times. I don't think you can withhold that, right? But if you're concerned that the individual who is submitting the request is then going to make that information publicly available and subject your officials, your employees to harassment, discuss with your attorney and be ready to fight the fight. I think you do have a good argument to be made because of the evidence that we have currently. I mean, and this is common, unfortunately, the death threats and threats of violence that local officials are receiving from the individuals who watch these videos and go comment on their websites. We have a comment or question here. Why do many of these auditors refuse to provide their name? I don't know. That's not an obligation on private citizens, though, right? They're a private citizen.
It's simply called exercising the Fourth Amendment. How is this guy given a seminar in First Amendment auditors and he doesn't know a basic question is why we would not give our names by exercising our constitutional rights? First Amendment, Fourth Amendment. How is this guy? This is the genius we got given as seminar to the public.
So the standard for being a private citizen is different than a public official. I'll just put it out there. Can you require them to provide ID or sign into a visitor log when visiting the facility, I'm assuming? The answer to that is yes, you can for security reasons. Absolutely.
No, fam, you cannot violate the Fourth Amendment for security reasons. As a matter of fact, Wyoming County made me sign in. It cost them $9,000 when I sued them, and there is no sign-in sheet anymore. Can they make you give ID to go into a building? No, they legally cannot. Do they do it? Some of these places do. We all know the state buildings in New York do. Somebody's gonna have to challenge this in court for sure.
You can put in place a security log or a visitor's log. Nothing in state law prohibits that. The Committee on Open Government does have some opinions regarding requiring individuals to sign in to attend meetings of public bodies. And as a general rule, you cannot require individuals to sign in to attend meetings of public bodies.
Town hall.
There's a little nuance to that. If the court is in a facility where the facility as a whole has a sign-in, but not just for the court proceedings. And the comment here from Sia is that assuming that you do the same for all visitors. Yeah, you don't want to be selective about who you make sign in. And how would you know, right? Unless you're, we're going to have you sign in after the facts. I don't see the PowerPoint in the chat box. I've added it. Hopefully everybody, if you didn't get a copy of the PowerPoint, it should be there unless you joined super late.
I got a copy.
Email me and we can get you a copy of that. Is someone else in your household, if someone else can you then withhold that personal information? I'm not sure what you mean by personal information. I don't know who this attendee is. It's anonymous on there. I don't know what you mean by personal information. No personal information of an employee ever has to be handed out or distributed. FOIL does not require their personal phone number or their personal email address to be disclosed to anybody. That's not in the Freedom of Information Law. And that can, and to be honest, should be withheld. And employees personal home phone number or personal email address is not a public record. It's on, that falls into kind of the privacy exemption under FOIL. So if that's what you're talking about, I don't know what you mean by withholding their personal information. Their name, there's no exception. There's no exception unless they're like undercover police work. There's no exception for not disclosing a public official employee's name, title, salary. Wait, the chat box is disabled. Why is the chat box disabled? Hold on, that's me. It should have been distributed to everybody. Chat. Well, you can't chat. You should be able to. Let me try this again.
Put a 1 in the chat.
Hold on, Jude. Let's try this again. I'm going to share this document one last time. Hold on. Let's do this. Hopefully, it is in. Holy tamale! My bad if the chat box is disabled. Sorry, Patty and everybody else. I just put a copy of the PowerPoint in the chat box, so go ahead and download it if you get a chance. Rebecca responded to a bunch of the other questions. Does anybody else have any other questions here before we sign off? Again, this will be made available for viewing in our members only section.
I have a question, Wade. Who pays you to teach mayors to violate the Constitution? That's my question, Wade. If you watch this,
I'm just looking at.
We're all members now, Wade. We all got your number, Wade. We're all members. Erie County fam watching out for the public. This jackwagon telling us this video is only available for members, but they made it a public record by sending it to public officials, and we got it in our hands through the FOIL system, baby.
Some of the other questions that FOIL, I'm not going to, it wasn't really FOIL, although FOIL is part of this. Does it assign employee only beyond this point? Yeah, if you don't have such signage in place, I will note this. Like, if you don't have a policy in place and you don't have signage in place, this standard that's right here, this Cornelius standard applies, okay? My recommended best practice, however, is to have an adopted policy and have signage posted so that kind of backs you up. It's one thing for the village clerk or the city clerk or whomever there is dealing with these individuals to say, hey, nobody beyond this point, and then to have that individual come out and say, well, there's no sign. This is a municipal facility. It's open to the public. I'm a taxpayer. I have a right to be here. Like, no, they don't, right? No, they don't.
Oh.
Have them be able to cite Cornelius versus NAACP. The government does not create a public forum by inaction or by permitting, but they're not going to remember that. Give them a note card that has that out there if you want to put that out there. Yeah, somebody posted in the Q&A dialogue box also some samples for no public forums. We'll work on something. If you want to post that up, we'll work on something. Linda wanted me to pass along the fact that, and then Linda from Rochester, they've really been having serious issues to the extent that she's been placed under police protection and the FBI is investigating, right? This is how serious these things can get. So you need to treat them very seriously. So with that said, there's no further questions. I hope this has been helpful. If you take anything away from this today, keep it simple. Adopt an official policy, whichever way you go. Post appropriate signage, whichever way you go. And train your staff, whichever way you go. If you're going to allow recording, train your staff on how to respond. If you're not going to allow recording, train your staff in how to respond. There is no substitute for training. Simply adopting a local law, simply adopting a policy isn't going to do you any good, because most of the videos that have generated negative responses for local governments, they revolve around the municipal employees and officials not handling the situation well. And that the only way you fix that, the only way you address that is through training. So with that said, as always, if you have any questions, don't hesitate to call me here at the Conference of Mayors or email me, wade@nicom.org, about First Amendment audits, First Amendment issues generally, Rebecca and I will be more than happy to help you out. And if you, or about any other municipal matter affecting your municipality. So I went over a little bit longer than I thought I would. So
what do you guys think? You heard it. Wade said if you had any questions, go ahead and contact him. There's his email address. You heard it from him. He said this is a private video between him and the mayors and how they're going to violate our rights. Unfortunately, Wade miscalculated when he made this and put it out there and then sent it to mayors on their public email, and it became public record. Wade, way to go. You guys let me know in the comment sections what you think about Wade and his ability to teach people how to violate our rights. But before we do go, I want to just bring one more thing up on the screen here. Hold on. And that is Craig Hennerdy's in jail. Was arrested for the people redressing their grievances. He got arrested and charged and is sitting in jail convicted of other people's actions of calling and redressing grievances. And the reason that I am putting that out there is that this guy needs some help. He needs some help. If you guys have the ability to donate to this guy, I would appreciate it. He's sitting in jail right now. He needs to appeal and he needs money. I don't often ask you guys to help out. If you guys can, I went ahead and put some links up. This guy is sitting in jail. He needs money for an attorney for appeal, and I believe he would win on an appeal. And all the times that I never really ask you guys for anything. I never ask you for anything. But if you guys have the ability and you want to help in the First Amendment community, please go ahead and get over to Craig Hennerdy's page and donate to him. I'm going to go ahead and
Vermilion County Jail. Your call has been accepted.
play this.
Hello, everybody. This is Craig Hendry coming to you from the Vermilion County Jail in Indiana, where the Indiana state government has been holding me as a political prisoner since October 16th this past year. They have announced their intention to hold me well into next year, even longer if they desire. Seeing as we are headed into a new year, I want to leave you all with my thoughts and perhaps a few predictions for the year to come. To start, I want to recognize that I am not the state's only political prisoner. There are a great many of us that exist in this country, from people who consume prohibited substances to those who refuse to pay extortion fees exacted upon them at the hands of the scoundrels known as government. Indeed, I am one of many. The very reason I began a YouTube channel was to expose what government employees are willing to do to non-aggressive persons. The government aggresses against and trespasses against people for no reason other than those persons' refusal to obey their commands. The evidence provided on this channel, as well as thousands of other media channels, is enough to show that the fact that all men are created equal is a fact that goes unrecognized by the men and women who call themselves government. As those men and women claim for themselves the right to aggress, assault, trespass, vandalize, kidnap, and steal from those that are not a part of their government gang. If you realize this, you are aware that this is a huge problem and will only grow unless an active, concerted effort is made to prevent it. I look at my own channel as a Paul Revere-style alarm-raising media outlet. In doing this, those in power have made an active, concerted effort to stop this, and that effort has resulted in me being here in jail. I will briefly mention that I have only a limited time left to acquire an attorney to perform my appeal for me, which will cost me upwards of $30,000, and any donations are greatly appreciated. 12,000 has already been raised. And now back to my thoughts.
So I don't ask often. Anybody who can, this man needs help. This appeal needs to be done, and this appeal needs to be won. So if you have the ability to donate, the links are in the page. Go down. I'll link this video in the description. If anybody here can, please donate and donate generously, because one man sitting in a prison cell for simply exercising his First Amendment rights, and other people petitioning redress of grievances, all Constitution protected activities, and you got jerk offs like Wade teaching these guys how to put people in jail like this. So we got to watch for jerk offs like Wade, and we got to help the community. And anybody who has the ability to help Craig Henry, I urge you to. I know I'm going to donate.
Many people have criticized or questioned my actions in raising awareness about the government gang and the dire consequences of their actions. I have received hate, love, constructive criticisms, and physical consequences for my actions on this channel. People mention that my life would be easier if I just go along with the government gang's demands, if I would withhold my criticisms or challenges to the government's thuggish behaviors. They are perhaps right, as many small business owners in New York found in the golden age of the mafia, it is easier to pay the extortion fees than to receive a broken leg. This line of reasoning would imply that it is easier to timidly accept subservience than to claim your equality as free men and women. It is in the name of justice that the latter is the path that I choose. Despite the broken leg, I will not bow my head to thugs. If a man says, "Pay me or else," he is rightly viewed as a thug. If that same man pulls out a badge, people these days are all too willing to extend their wallets. In each scenario, there is a victim, the person being robbed. However, government brainwashing in public schools has convinced a great many that if they do not willingly pay the man with the badge, they are the thug, and the thief the victim. This is the slave's mentality. I was once a subscriber to these beliefs. It is easier to go along with the crowd. I no longer do. I would urge you, my audience listening, to steer clear of this slave mentality. Many will protest that they cannot afford to, that the potential punishment is too costly. To those people, I would say, take a look at your grocery bill, gas and energy bill. Look at the amount of money you pay to the government gang every year. Look at your future and ask yourself how much longer you can afford to be a slave. How much longer you can live on your knees. Probably not very much longer. And living on your knees becomes less and less comfortable all the time. Stand up. Countless times history has repeated itself. To think it will be different this time would be naive. Governments get big. They issue arbitrary commands and demands. They print paper money. They go broke, run up a huge debt, try to print their way out of the debt, and usher in an era of poverty and tyranny. Each time people wax lyrical about how it's easier to comply until, of course, they are starving or rotting in cages, or in some cases killed. This is a different way of saying back the blue until it happens to you. I do not think at this point anyone can deny that the United States has followed this trend to a T. And the next year, 2025, will mark an accelerated progression towards the result. Be vigilant, stay on your feet, become a new person this year. Sincerely, Craig Henry.
So anybody who's willing to help or able to help, I urge you to help this man. He is in dire need of help. He's sitting in a jail cell through the New Year's, through Christmas. I would urge you, if you could, help this guy out, to do so, because we got to stick together like a family out here. And I'll tell you what, this guy is locked up for simply exercising his constitutional rights, fam. And get over there and help if you can. I'll see you guys in the next one. I hope you guys enjoyed the exposing of this slime ball Wade. And if you guys can help Henry out, get on over there. I'll put the link in the description. You guys have a great night.